Yes.
My lord, that is basically what my submission is, my lord. Unless there is a mandate from the government that it has to be provided, that reservations have to be provided, my lord, only those ones can be read into this rule. That's what I'm trying. That's my submission, my lord. When it says required to be provided, it's different from admissible, my lord, because in all of these instructions, when we read, it says admissible, 5 years admissible.
You have read that once, page 161 also,
Yes.
wherein that relaxation provision is there for the in-service employees.
Relaxation for departmental candidates up to 5 years. This up to 5 years, my lord, is in accordance with the instructions or orders issued by the central government. That's what it says. So the basically my argument is you can only relax up to 5 years, my lord. That's it. And the rest of it, the SC, ST, because it's not in mandatory term. It's not provided that you have to provide, you have to include all of, otherwise, my lord, the entire thing they would have to include in the advertisement also. There are so many people who would want to apply. It would amount to, my lord, discrimination.
Okay, those in the in-service candidates, they belong to a different category altogether.
Correct. And they have 5 years already.
They belong to a different category, isn't it?
Yes.
It's not that they are the reserve category.
No.
So availing that benefit of 5 years will not disentitle them to apply for the job merely because it's unreserved.
No, because
They can.
They can, because that is not about SC, ST, my lord. He can avail 5 years benefit, my lord. There's no problem with that.
But that 5 years is not sufficient.
For him, it was not. He missed it by 6 months, my lord. Unfortunately.
Okay, let me hear the other side. You
Certainly,
may
my
reply
lord.
if you
Yes.
want to.
My lord, first of all, my lord, half of the, my lord, time he has argued on the educational qualification of the respondent number 5. But that is not a pleaded case, my lord. So, my lord, no amount of evidence that has been produced before the court cannot be taken into consideration in absence of any evidence. I have the answer to it, but whether I would require to make submission on that. But it is not a pleaded case. His simple case was that I was disqualified. The first list was published on 22. First list was published on 21/12/2022. That's the eligible candidate, where my name has not been figured, and his name was there. Then later on he came to know, while the result has been declared, that I am selected, he is not. And thereafter, my lord, will find I was appointed after the offer, etc., on 7/3/2023, and he filed this writ petition in July. By that time, I have left my earlier job. I have come here. In my post, someone else has already been inducted.
What was your earlier job?
My lord,
You were a departmental.
I am a departmental candidate. I was working, my lord, in the NIT itself in a different post.
Multitasking
Staff, my lord. Staff.
MTS.
MTS. So I was, as per the, my lord, advertisement, I have applied, I have been selected, I have joined. There's absolutely no mala fide urged either against the NIT or, my lord, against me, that I have misrepresented my age or my certificate, etc., qualification. I have joined, I have already rendering services more than 2 years by now. Now, second aspect of the matter, this honorable court will, in exercise of writ jurisdiction, will confine to the decision-making process, not to the decision itself. Now, here the decision-making process, which he is alleging that it's violation of the rules, etc., etc., those are not impugned In fact, my lord, pursuant to the first eligible candidate notice dated 21/1/2023, my friend has pointed out that I have submitted a representative referring to various notifications that I presume you have rejected as being an overage. So therefore, you consider these are the notification under which I am entitled. Now this screening committee of the NIT takes my complaint and they find that, yes, he is entitled. A fresh list of eligible candidate has been published, 4/1/2023. He has not uttered a single word against this second list that has been published.
Have you annexed that?
It is by the my lord,
NIT?
respondent number 125 affidavit they have my lord, mentioned.
4-1?
4/1/23, my lord, in the affidavit in opposition filed by respondent number 124. It will be at page 41. Yep, no. Oh, yes, sir. Yes. Page, as you also got it, page 41 of the affidavit in opposition filed by the respondent 124. This has been filed on 16/8/2024. Actually, in the principal bench, that system has been started with making the serial pagination, one after another pleading.
Yes,
So that makes it little easier, perhaps.
correct.
Now here, looking up for this affidavit, that affidavit, it takes time.
But that also, again, it's not foolproof.
Yes, that is there, because I did not
There are-
notice the
I
affidavit
found, in some cases, paginations are different.
different. Because I filed my affidavit in opposition, the another one files affidavit. He takes the note of the last page of the writ petition, and I also take the last page of the writ petition. Then I file my affidavit opposition, same number with what the other one is filing. It's there.
It's a page number
It's a 41, madam.
41.
Lordship.
Oh,
Of the affidavit in opposition filed by respondent 124.
Yes, 41.
41.
This is the second list.
This is the second list. First list he has enclosed with his writ petition, page 208. Now this is the second list. And Lordship will find at page
You're at serial number?
147, page 44.
And the petitioner?
But his serial number is maintained at page 41, serial number 20.
20.
20. This is only the list of eligible candidates. And not only me, my lord, this next man, my lord, will find at page 44, 148 serial number. He is also the person who was rejected on my same ground. Page 44, serial number 148.
$148.
Yes, one
Yes.
Kalyan Das is there.
Yes.
In their affidavit, they have specifically said this person was also rejected because of the overage. Then, after applying the notification in its true perspective, both of them were made eligible, and thereafter they had appeared. Now, thereafter, my lord, all the exams were my lord, held, and I became the topper, my lord. So there is no question of, my lord, slashing with the merit by giving this age relaxation, etc. The merit has not been compromised. Now, my lord, what, my lord,
This notification, otherwise it does not say in supersession, isn't it?
The earlier one.
Yes.
Yes, my lord, it does not say, my lord. These are there, the administrative, my lord, education is basically, my lord, that strict, my lord, rules, they may not be observing. But bona fide has not been doubted by, my lord, the writ petitioner also, my lord. Now the prayer in the writ petition, your lordship will find at page 28. Appointment of the respondent number 5 to the post of Superintendent B should not be. Page 28.
Yes.
But sixth line from as to why appointment of respondent number 5 to the post of Superintendent B should not be declared illegal, and as to why notification number so and so dated 22/2023 should not be modified to the extent to as to why the order number so and so dated 7/3 should not be set aside and quash, and to why petitioner should not be appointed to the post of so and so so and so. So basically he has challenged my appointment, nothing else. The decision making process, if at all, that has been flouted by the NIT by taking a decision to employ the provisions of both the notification, one for the departmental candidate and second is for the reserve category candidate. So therefore, my lord, the question of, my lord, maintainability also of this writ petition also arises.
See, one thing, the post is unreserved,
Yes.
one post.
Yes.
Can a reserve candidate participate?
Yes, my
And,
lord. My lord, that is the, my lord, whole, my lord, the.
And at the same time avail of
That is
the
that
whatever relaxation?
Yes, that is the whole, my lord, objective of the scheme of, my lord, making this reservation. My lord, it isn't subtle, my lord, that this reservation, I'll come to those judgments, my lord, at a later, what is the objective, but in nutshell, what may I say, my lord? Because of the economical, social, etc., various backgrounds, these, my lord, the reservation has to come into fore. And these are categorized as a vertical as well as horizontal. Now the vertical are only with the classes of communities, SC, ST, OBC, nothing else. Rest, whatever comes, these are all horizontal. And to maintain this quota of 50%, it has also been also already held. But if someone, my lord, gets selected under a, my lord, say ex-serviceman quota or, my lord, physically handicapped quota or a sports quota or a women quota, if selected, then he or she will be brought to the respective category of this vertical column. That is the, my lord, vertical and so therefore by maintaining this process, the 50%, below 50% of ratio will be maintained. So there is no bar for appointment. And a reserve category, I have applied for reserve category as an ST. And I stood on merit much more than the general candidate. I will not be kept in the ST category. I will be taken to the general category candidate. So thereby giving a opportunity to another person to come up. Because I already qualify in merit, so I will be taken to the general category. That is the law, right from the Savarwal to Indraswani and Nagraj and all, that is well settled, perhaps there is no quarrel on it. So that is the beauty. So anyone can apply for an unreserved post. It's a general post. But so far as reserve post, and this based on the roster, these vacancies, these are always, advertised as per the roster. When the roster will speak of a ST or SC, in that case, no general person can apply. It is not open for him. It is only for the ST or SC candidate. Whichever.
But it does not work the other way around, isn't it?
My
If
lord?
it's for general,
Lordship.
even ST can apply.
Well, that's what his submission is, but that is not the law, my lord.
My lord,
That is not the law, perhaps.
let me just clarify, my lord. I'm sorry to interrupt, my lord. My submission, my lord, was that if someone takes the benefit that is only available to SC, ST, using that benefit, my lord, he cannot contest for an unreserved post. That is my submission, my lord.
Yes, so what he says, my lord, if I avail, my lord, any benefit of this 5 years, etc., as a, my lord, ST candidate, I cannot, my lord, compete for the...
Yes. Without that benefit, you are overage.
No, what he is saying, my lord,
So you have availed for the benefit, but you cannot contest for the unreserved category. This is what he's saying.
just that again, my lord, my submission then, my lord, I am not entitled to the age relaxation as a scheduled tribe candidate. That's what he is trying to say, my lord. Because moment I apply, then this is unreserved post, so I cannot. So indirectly he wants to mean that if, though it is applicable, but since it is an unreserved post, here he admits that this notification is applicable. But
What he
if-
says is that since it's an unreserved post,
Gotcha.
you are to contest as an unreserved candidate.
Gotcha.
You cannot bring in your
Gotcha.
quota thing,
Gotcha.
that I should
Well,
have
this has
relaxation.
been- well, this situation, this proposed, this past, that has been clarified in the Jitendra Singh case, my lord. I'll take your lordship, my lord. It says, my lord, these are the relaxations, are not, my lord, reservations. These are concessions. These are only with regard to the eligibility criteria. It is only to bring this downtrodden, either whatever conditions, my lord, they to bring them at par with this person to contest. There is no, my lord, so far as concession with regard to the merit. It is not exactly the reservation what trying to, my lord, portray here, my lord.
You're saying merit is a separate criteria altogether.
Altogether, my lord.
These concessions, relaxations only to bring that person
Yes, my lord.
to the playing field,
Playing
so that he can also compete.
He can also compete.
Once you're in the playing field, merit will come.
Merit will come. Yes, my lord. That is, my lord. That was, my lord, in
And
the
if
words
you are,
of- in the words-
if you're in the playing field, you are contesting for a particular post meant for a particular reserved category, you will be considered against that category only, not for other categories. But then again, you say that if you achieve such merit, which is more than the last candidate who is from the general category, then you can be appointed in the general category.
My lord, these things will, my lord, wholly these things will come when more than one, my lord,
More than
post
one
are-
post is there.
when the categories are specific. For scheduled caste this much, scheduled tribe this much, for open this much. There only, my lord, this question, but here it is only one.
One post.
One post, and everyone can apply. There's nothing, my lord, no, my lord, notification, nothing bars that any reserve category candidate is, my lord, restrained from or debarred from applying for the general post. But so far as reserve category posts are concerned, it is specifically barred. The advertisement itself says. It is in general application, my lord.
You have availed of age relaxation because of you being a in-service candidate.
Yes.
Secondly, you have availed age relaxation in view of you being an ST category.
Lordship.
Can you avail both?
Yes, my lord. My lord,
Possible.
the rules, the judgments what my friend have referred to, some of them I have gone through, some of them of course not, my lord, but the majority of them I have gone through, and there always the rule is either silent or rule speaks contrary. For an example, that one of the judgment that has been referred to, Nirva Kumar Dilip Bhai Makwana. You have referred to SCC, no?
SEC, yes.
Is it that full bench,
No, my lord, no. This is,
Maharashtra?
no, my lord, this is 2000, this is Supreme Court, my lord. I don't know, my lord, whether this will be same paragraph or not, my lord, I am holding that SCC matter.
Which decision?
But 2019 7 SCC,
2019 7 SCC, yes.
383.
It's with me. Which paragraph you want to?
No, it will be paragraph 14. Factually, my lord. In the meantime, the state government in its general administration, department-wide government resolution dated 11/12/86 formulated a policy to the effect that members belonging to ST/SC categories who are selected for appointment to direct selection to any service or post included in the state service or in the subordinate services on the basis of their merit shall be considered for appointment on unreserved posts which are filled in or on merit along with other general category members. As per the said government resolution dated 11/12/1986, such appointment on merit of the members belonging to such caste and tribe shall in no way affect claim of the members of such caste and tribe for appointment in the service or on the post reserved for them under the government order issued from time to time. The state government-wide circular number so-and-so dated 29/1/2000 clarified that a reserved category candidate, if has not availed of any relaxation, his age limit, experience, qualification, member of chances to appear in the examination, the said candidate will be adjusted in the open category, and in case candidate has availed any of the aforesaid relaxation, he shall will have to adjust against the reserved seat. So this is in that context. Unless this circular is challenged, the court cannot give any other judgment, because rule says if you avail the relaxation, in that case you will not be adjusted in the reserve, in the general category candidate, so far as this 2019 SCC is concerned. But no such rule, rather Lord Chief has rightly seen, my lord, the rule 5, it gives a wide power, my lord. So far as, my lord, this, my lord, the age relaxation for the departmental candidate, it is itself, my lord, is a separate source of, my lord, pool. My lord, the direct recruitment, my lord, in the direct recruitment, they are trying to make a two pool. One is the open, one is the pool of the direct recruit from the departmental candidate. And the objective is very clear: not to get their experiences go waste. Department wants their experiences. That is the reason. And by service with the state, My lord, these are all, my lord, I'll come to that. My lord. So therefore, my lord, this has been specifically provided in the rule that departmental candidate will have a 5 years relaxation. If this would not have been mentioned, that departmental candidate could not have been, my lord, given this benefit, my lord. And this, so far as the circulars are concerned of the, my lord, central government, these are not suo motu applicable. Central government makes this circular for various other authorities to, if they wishes to import, then they can import. Now here is a case. In this particular case, Lordship has seen the Rule 5 as well as the advertisement. It's clear indication that if required, then this circular benefit of this circular will be given, and not only confining to the this schedule caste, etc., but also this clause 5 of the rule says other categories as well. And this is, my lord, non-obstante clause, my lord, though word, my lord, notwithstanding has not been mentioned. This page 82, the rules. The reading of the, my lord, clause clearly, my lord, appears it is a non-obstante clause, my lord. And it clearly means, my lord, this provision of, my lord, the 5 years relaxation for the departmental candidate is embodied in the rule itself. My lord, you will find, my lord, the next clause of the page 83, qualification and other requirements of selection. Qualification and other requirement of recruit various non-teaching posts are given in detail in the annexure. And this annexure, your lordship will find, my lord, 84, starts with 84, and the relevant lordship has already seen, my lord, that is with regard to the post of superintendent.
Which page is that?
My lord, 83, clause 7 says qualification and other requirements of selection.
Yes.
Qualification and other requirement of recruitment various non-teaching posts are given in detail in annexure. This annexure is at page 84.
Yes, where is the...
Relevant is 161.
superintendent?
Page 161.
161.
Lordship. So it's a part of the rule. And clause 5 said, notwithstanding, my lord, of course not with that, or nothing in this rule shall affect reservation. So by giving this 5 years, it will not affect the reservation under the general circulars, those are applicable. So the rule-making authority has, my lord, clearly, my lord, with the objective to give benefit over and above this, my lord, relaxation for the departmental candidate to also the reserved category candidate as well as, my lord, physically deformed, etc., my lord, all are, my lord, ex-servicemen, etc., they thought that it will also be given. So rule having, my lord, prescribed, the judgment, whatever have been cited, there nowhere, my lord, these provisions are there, my lord. Though it's been said, my lord, I have not gone through the judgment, of course, my lord, of the Punjab and Haryana, but what I find, my lord, for every NIT, the Board of Governors has to adopt, my lord, respective rules. For the INIT Mizoram is a different, NIT Silchar may be different. And the advertisement, your lordship will find page 202. 201 it starts, that superintendent is unreserved post, so there is no doubt about it, my lord. then general instruction starts from 204. Page 204.
Yes.
Now, my submission, my lord, rule is very clear. My lord, the rule of interpretation, my lord, first of all, my lord, the literal interpretation should go, my lord. Now here, the rule provides, annexure provides that for the purpose of post of superintendent, 5 years relaxation will be for the departmental candidate. Rule 5 of the rule says, notwithstanding the nothing in this rule shall exactly the words, my lord. Page 82, 83. Nothing in this rule shall affect reservation, relaxation of age, limit and other concession required to be provided for the candidate belonging to scheduled caste, scheduled tribe, other backward classes, ex-servicemen and other special categories of person in accordance with the other issued by the central government from time to time in this regard. So rule is very clear. If any, my lord, doubt or two meaning can be possible, then some different, the purposive interpretation or other interpretation is permissible. But here there is absolutely nothing. Even for my lord, purposive interpretation, my lord, the rule has to be interpreted with the objective sought to be achieved. What this clause 5, by incorporating this clause 5, what objective they have sought to achieve. And what, so far as my lord, rule, the annexure, my lord, regarding departmental candidate relaxation, what objective they have sought to achieve by incorporating that. Understanding that, they have, my lord, advertisement, they have clearly mentioned in, Lordship may kindly see, my lord, page 207, 25. Age relaxation in different categories.
Shall be as per Government of India's norms.
Government of India norms. So those are the notifications which are on, my lord, on force, my lord. The authority initially, the record also, of course, will, my lord, reveal whether I was considered for, initially given as a departmental 5 years or the, as a, my lord, ST candidate, I was given 5 years or I was not given at all. Because that appears to be little my lord, silent on that, my lord. They will be clarifying it. But they have realized that I am entitled to both. And they have given. Now, this decision is not being challenged in the writ petition. Ample opportunity was there to amend the writ petition because this court will only, my lord, go by the decision-making process. And on the basis of this rule and the advertisement, prima facie, even otherwise, every executive order, unless is set aside or annulled, deemed to be passed correctly. That is under the Evidence Act as well as various pronouncement as well, my lord. So now they have taken a conscious decision that yes, these two notifications are applicable based on the rules and the advertisement. Unless this is challenged, can only my appointment be challenged? After all, this is a court of equity as well, which we will see on the both sides. Now, for a moment, pausing from this argument to the other argument with regard to the education qualification. In a way, writ petitioner trying to project a case that 2012 I have completed 6th semester in a particular course which was not recognized by anybody. Then press notification or government public notification comes that these AMI students or persons who have undergone 3 years course are not being recognized anywhere. So therefore, UGC along with the government policy decided to make it a recognized degree course. And the Director of Civil Aviation is not an expert body to give syllabus or for graduate course or undergraduate course. What it says, it is only the training. It gives the training, it recognizes the training. It is not an expert body of the education like NCT or UGC. Under that scheme, this Singhania University, who was also running this AMI course of 3 years, as I have done from this School of Engineering Technology, Nirmana. Similar course I was doing. I have done, they are also pursuing that. So they have introduced a course that those who have not those who have done this 3 years course, if they do a 6 months course, in that case, we will be conferring a degree. Like if you also will recollect, at one point of time, Delhi University also used not to recognize our degrees and we have to go for a bridge course there. Then only we used to be considered as a graduate for the purpose of master degree, etc. So this, and thereafter I have appeared this 6 months exam course. I have appeared the exams, then thereafter they have given me the certificate, which is recognized by UGC, a government body, and the rule requires that a recognized first-class degree from a recognized, government recognized. For a moment, once again, my lord, will find page 161, first-class bachelor degree or its equivalent from a recognized university or an institute in any discipline. Now, my lord, this university is recognized by the UGC. The list I have enclosed, which clearly reflect among various universities across the country, including this Singhania. It is in affidavit in opposition, reply. Bye. Dated which one? Too many pleadings, it takes little time also in that. Press for the paper what? Additional affidavit somewhere else is there. Let's just check it. Well, this is reply we have filed against the affidavit, additional affidavit filed by the writ petitioner dated 27/5/2024. Well, in my reply, it will be, the page starts.
No, relevant page where the,
Yes,
your
yes,
institute
Yes.
is given.
Well, this starts, well, from page 12.
12.
And relevant, your lordship will come to page 45, serial number 761.
Singhania University.
Singhania University. Though they have, by very words, they have not stated, they're trying to project a case or develop a case as if this is a manufactured document or I have obtained in a different way. If that be the case, my lord, let the university be a party, let the, my lord, this UGC be a party, my lord, in this case, that will be clear. But so far as NIT is concerned, they want a degree from a recognized university, which they have got.
What is this list regarding? It's by the UGC,
It starts from page, yes, my lord, UGC, my lord,
page 11,
page 12, my lord,
12.
12. This is as on 25/1/23, the list of universities they have recognized.
No, these
State
are the list of universities which have been recognized by UGC.
UGC. It includes all state university deemed to be university, central university, private university, state university deemed to be, all the, everything.
Singhania is from Rajasthan.
Rajasthan. The institute where I have done my sixth semester is also from Rajasthan, Alwar. This is appearing,
Is it available here?
my lord? Yes.
That six months course?
Well, I have stated, my lord, I have stated in paragraph 4, my lord, complete, if I am permitted to read, my lord. This has not been denied by them. There is no affidavit reply against this, my lord. Otherwise also, this is not a part of the, my lord, writ petition. It is not a pleading, my lord. Nonetheless, we have replied, my lord, paragraph 4, page 3, my lord. May I read, my lord, the entire paragraph, my lord?
Yes.
That in reply to the paragraph number 5, 6, 7, and 8 of the additional affidavit, it is veracious to submit that the respondent number 5 had completed the 3 years full-time AME avionics course from the School of Aeronautics, Nimrana, Rajasthan, India in the month of August 2012. Thereafter, the respondent number 5 had further completed the 6-month course at Singhania University, Jhunjhunu, Rajasthan, India for pursuing Bachelor of Science degree in Aircraft Maintenance Engineering, for short AME, and was awarded Bachelor of Science degree in AME in 2018. It may be elaborated here that since a large number of AME students are spending 3 years in AME training, institute do not get employment as these courses are not recognized by any government body as degree or diploma. The University Grant Commission UGC in consultation with the Ministry of Civil Aviation has introduced a BSc course in AME in order to safeguard the interests of such AME student. In this regard, a public notice vide file number so-and-so dated 8/3/17 and another public notice vide file number dated 1/5/2007. These two public notice lordship had gone through, my lord. My friend has taken your lordship, my lord. Those two, my lord. Pursuant to this, respondent number 5, who had completed his 3 years full-time AME training course from the School Aeronautics at Rajasthan, India, had further completed the 6 months course in Singhania University in Rajasthan in the year 2018, thereby obtained a degree of BSc in AME. In this regard, it may further be stated that since the model syllabus of BSc course in AME is the same with the syllabus of 3 years AME training course which the respondent number 5 had undergone from the School of Aeronautics, Nimrana, Rajasthan, the Singhania University, which offered the BSc honors course in AME with the approval of the UGC, had accordingly accepted such 3 years course completed by the respondent number 5 in the process of conferring BSc degree in AME. However, as the respondent number 5 had to further complete another 6 months course in Singhania University, during which the basic science subject pertaining to AME course were studied, he accordingly completed this course as well as successful to obtain the BSc degree in AME. If this is false, this is not been countered. If this is false, my lord, there has to be an inquiry, my lord. And any adverse order, my lord, in absence of the, my lord, the university or the NCT and the UGC. And it is, my lord, well settled, my lord. Statements which are not, my lord, denied are deemed to be admitted.
All right.
Rather, in one case, Supreme Court, my lord, I have some judgment to be referred to, my lord, and mostly on the interpretation, but one case which will definitely, my lord, throw some light on the issue, my lord. There, my lord, the appellant had appeared for the DSP exams, and she claimed that she was a departmental candidate, so therefore age relaxation she is entitled. But then she was denied. That was then she filed the writ petition saying that as a departmental candidate I am entitled. Then ultimately on scrutiny it is found that the rules which was referred by her came up, my lord, the post which was advertised is a much prior to the joining her in the service. And therefore, writ court said, single judge has said that this is not applicable, so thereby writ petition was dismissed. Then they went to the appeal. Then writ appellate court also dismissed. Then Supreme Court, while interpreting the provision, basically with the objective for which, my lord, this ST/SC has been, my lord, this benefit has to be given. There, my lord, she claimed 10 years relaxation as a woman. There is a circular. She is entitled to 10 years relaxation as a woman candidate. So there, this court said, my lord, that for the purpose of purposive interpretation also, you have to go by the very objective. And while going for the objective, why this particular notification or the rule has been made for giving benefit to the woman has to be gone into. And if this is gone into, it will be have an universal application to everything. So that benefit has to be given, although the rule says contrary to it, because that rule says that age relaxation will be given only to the persons which were mentioned in the rule itself, and this woman category was not there. So rule said only the categories of the persons will be entitled to the age relaxation, where woman was not there. But then Apex Court, my lord, while interpreting, my lord, this, my lord, the particular act and rules, my lord, they have interpreted to that extent, my lord. So here also, my lord, looking into, if your lordship permits me to, my lord, or will continue as your lordship.
Are you here tomorrow?
My lord, otherwise I was not to be, but then if your lordship inclines to take up tomorrow, or otherwise I'll definitely pray for a different day.
We can't complete this matter tomorrow. I think I have to hear Mr. Bilarameng also. You're for the NIT?
I'm together. I'm together. We are together.
And who's for respondent number 5?
Five.
Oh,
Five.
he's
I am
for-
five. I am
Oh, I
five.
see.
I am five.
Okay.
My friend is appearing for the NIT class. NIT.
You have the records with you? You don't have? Okay. Tomorrow we'll have it?
That's okay.
You call the thing?
But I think these two maintainability, if it is gone into first, whether it will be maintainable. Firstly, because the process making has not been challenged here. Only the decision has been challenged. So on that count. And secondly, whether he'll be still pressing the ground for the certificate. If that be so, in that case, perhaps the Singhania University, then the UGC, and then DGC, these authorities have to be made party to it.
What are all the institutes? Singhania,
Singhania University,
that's in
Rajasthan.
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 And the other one,
Nimrana,
Nimran, this is also in Rajasthan.
it is also in Rajasthan.
But this is not a university, it's a school of aeronautics.
It is an institute. A School of Engineering and Technology.
Then the third one,
The University Grant Commission, because they have recognized the university who has issued me the certificate.
no, apart from UGC, any other institute involved?
No institute, no, my lord. No other institute.
Only Nimran and Singhania.
Singhania.
Okay.
Then Director General of Civil Aviation. It has been argued that, my lord, that they have not prescribed any syllabus or recognized university. But then, my lord, they are not the authority to prescribe, my lord, because it is the UGC or other authorities only, because they are not education body. For the purpose of university, etc., it is always the UGC. For the purpose of, my lord, the colleges and these schools, it is NCT nowadays.
All right. This is in the part 1 list, isn't it?
Part 1 list.
So that's why you'll come back in the part 1 list tomorrow. Please write, hearing remains inconclusive. List this matter again on 19th of August 2025 as the first item in the admission column. Court Master, you staple this in the file, okay? The notes.
वो लोग तो इन làm lâu đại lâu lâu cứ check